Hi everyone, thanks for joining us for this presentation. This presentation is going to look at the legal history of Japanese whaling, or at least look at a few aspects of that history. So with that, let's get started. This presentation is framed around several eras of Japanese whaling. Those eras, from a legal perspective, can be defined as shown on this slide. The first obvious era is massive commercial capture. Then between 1972 and 1982, we see some cultural shifts in terms of attitudes about whaling, and we eventually get the commercial whaling moratorium. The moratorium remains the law, but Japan eventually chooses to engage in scientific whaling, and this ensues for decades with two major legal interventions: a case that was brought in the International Court of Justice, and a compliance issue raised under the Convention on International Trade in Endangered Species, or CITES as it's known. Following that intervention, the CITES intervention, Japan withdraws from the International Convention on the Regulation of Whaling and its governing body, the International Whaling Commission, and resumes commercial whaling. So with that as a framework, we're going to walk through some of these eras and look at various legal issues in brief, so that you have an understanding of the legal history of Japanese whaling. The main treaty that regulates whaling activities is the International Convention on the Regulation of Whaling, which entered into force in 1948. Prior to that, though, multiple efforts ensued to manage whaling. A glut in the whale oil market during the mid to late 1800s precipitated the first major effort to regulate and control and manage whaling. Now, it wasn't from the perspective of conservation, it was from a market management perspective. The major whaling companies themselves signed intercompany agreements to better control market supply. However, by as soon as the early 1900s, it was clear that these efforts, while perhaps regulating the whale oil market, had done nothing to address declining whale populations. It was in 1931 when the League of Nations adopted the Convention for the Regulation of Whaling, which applied internationally but only prohibited taking calves, immature whales, female whales accompanied by calves, and right whales. Ultimately, this treaty also did little to prevent the dramatic declines in whale populations, partially because of a lack of an enforcement mechanism, and untold whales lost their lives to supplying commercial marketplaces. Given those ongoing declines, whaling countries began to renegotiate or began a new negotiation following the end of World War II for a new whaling treaty. Ultimately, in 1946, Argentina, Australia, Brazil, Canada, Chile, Denmark, France, the Netherlands, New Zealand, Norway, Peru, South Africa, USSR at the time, the UK, and the US adopted and signed a new whaling treaty. This treaty had a similar name, but it's important to keep them distinct. The treaty that we have today is the International Convention for the Regulation of Whaling, which ultimately ended up entering into force 2 years after adoption in 1948. Interestingly, Japan didn't participate in the negotiations to develop the treaty, but it did submit its letter of ratification soon after entry into force. So Japan had been party to the treaty since 1951. The next few slides provide a very brief overview of the International Convention on the Regulation of Whaling, or ICRW, as we'll start to call it. First, the object and purpose of the treaty is to provide for the proper conservation of whale stocks and thus make possible the orderly development of the whaling industry. This is the central goal of the treaty, and as you can see, the treaty concerns both conservation and the whaling industry. The treaty comprises both the treaty text itself and then what it calls a schedule. So whether a schedule, appendices, or annexes, which you're probably all familiar with if you've watched some of these videos or you work at all in international environmental law, these are really common structural approaches to address the need for flexibility to manage changing circumstances. So in the case of the ICRW, the schedule is legally binding, just like the treaty itself, but it's much easier to amend than the treaty text itself. The International Whaling Commission, or IWC, is the governing body of the treaty, and it comprises all of the countries who are party to the treaty. The IWC is the body tasked with, amongst other things, amending the schedule. And it does this when 3/4 of the IWC members agree. According to Article 5 of the treaty, the IWC can amend the schedule to establish, amongst other things, 1, protected and unprotected species, 2, open and closed seasons, 3, open and closed waters, including sanctuaries, 4, size limits, 5, time, methods, and intensity of whaling, and 6, gear restrictions. So multiple opportunities and angles through which whaling can be managed. Importantly, although once the schedule is amended, the rules are legally binding, parties can opt to object to an amendment of the schedule. This is the equivalent, essentially, of taking what we call in international law a reservation. A reservation is a legal privilege that allows states to become parties to a treaty, but unless explicitly prohibited by a treaty, exclude or modify the effect of certain provisions of international law. So it's really based on this idea that international law exists when states give consent to it, and as a function of a system based on consent, states get to choose as the central actors in international law which law applies to them in certain circumstances. So there are situations in which reservations are not allowed, or certain reservations can be viewed as illegal under international law. Another feature of the ICRW that's critical to the Japanese whaling saga is Article 8. This article provides for what we call special permit whaling. Essentially, this is the legal basis for Japan's scientific whaling programs. Article 8 provides that any contracting government may grant a special permit authorizing the killing of whales for purposes of scientific research. It also then says that the proceeds of such programs shall, so far as practicable, be processed and dealt with as the government provides. Finally, it says that governments should share their scientific research. Although unnecessary per the treaty text, the schedule, under paragraph 30, requires that contracting governments, so this is what the IWC and the treaty call parties to the treaty, so these contracting governments, provide the special permits in advance to the IWC for review and comment. So there's functionally something like an approval process that the schedule establishes. The schedule also requires that any proposed permits specify the objectives of the research, the number, size, sex, and stock of the whales to be taken, any opportunities for scientists from other contracting governments to participate, and any implications for conservation. So the schedule really has built out how permits should be issued under this special permit whaling provision, Article 8 of the Convention. In addition, the IWC has adopted a number of resolutions that define criteria for issuing special permits. Proposed special permits are to be reviewed by the IWC Scientific Committee, according to these resolutions, with the following criteria in mind: whether the scientific research to be conducted will assist ongoing comprehensive assessments of stocks or other quote unquote critically important issues unable to be resolved through non-lethal research. Whether the proposed research will provide reliable answers to these questions, and whether such research will have an adverse effect on whale stocks. So ultimately, what the IWC members by resolution are trying to do is really clearly define the relationship between the whaling, the lethal whaling that's occurring under the guise or as scientific research, and ensuring that the scope and nature and scale of that program is scientifically designed to get to the questions that the scientific program is allegedly asking. So ultimately, here on scientific whaling, the law managing these programs derive from the ICRW, so the treaty itself, the schedule, and resolutions adopted by the IWC. So it's important to just keep in mind a tiny distinction here. Whereas the schedule can only be amended if 3/4 of the parties agree, resolutions can be adopted by a simple majority. So you have different layers and scales of multilateralism involved in establishing these rules, which, can get complicated. And I think, legally, it depends on whether that matters. But from the perspective of Japan, it matters, right? So it definitely can start to feel to Japan like there are the slimmest of majorities at times deciding the rules that apply to their scientific whaling programs. So we've reviewed the basics of the ICRW, so now let's refocus back on the eras we introduced at the beginning. As I mentioned, the second era is most fundamentally marked by the major cultural shifts around the acceptance of whaling. By 1972, the conclusions of the Stockholm Conference on the Human Environment called for a 10-year moratorium on whaling. So back in 1972, it was only in 1982 that the IWC agreed to amend the schedule with paragraph 10E, which is functionally the commercial whaling moratorium. The amendment passed 25-7 with 5 abstentions. So you can see here on the slide that the moratorium provides that catch limits for the killing for commercial purposes of whales from all stocks for the 1986 coastal and 1985-86 pelagic seasons, and thereafter shall be 0. So you'll recall that we talked about objections, and as you can see also here on the slide, Japan, Norway, Peru, USSR at the time, and Iceland, we'll come back to Iceland, lodged objections or currently have reservations. Today, only Norway and Russia still maintain their objections, although Russia does not engage in commercial whaling. So there's a little bit of legal technicalities about Iceland. It didn't actually originally lodge an objection in the window in which it had an opportunity to, but in order to not be legally bound by the moratorium, Iceland actually withdrew from the whaling convention and then re-ratified it at a later date, at which point it took a reservation. So it raises multiple legal questions that have been complicated and controversial for people to resolve, but they had been commercially whaling for years under their reservation, and only recently have they pulled back on commercial whaling because it's no longer viewed as financially viable. Norway continues to engage in commercial whaling under its objection and actually takes way more whales than Japan. So all told, under the ICRW, there are three ways under the treaty to engage in whaling. So, and then there's withdrawing from the treaty, right? So just removing yourself from the process. But the three ways to engage in whaling under the treaty are through an objection, we've just discussed that, through special permit scientific whaling, which is what Japan was doing, or through Aboriginal subsistence whaling quotas, which we're not going to talk about here. And then, as you can see, I have a number 4 here because it becomes critical. Withdrawing from the ICRW can also be an avenue to commercial whaling. So we talked about this, but recall that the treaty text specifically leaves issuance of scientific whaling permits to the discretion of individual contracting governments. However, at almost every IWC meeting since 1987, the contracting governments have passed 1 and sometimes 2 resolutions, so specific resolutions determining that Japan's proposals for special permits fail to meet the established criteria. And so maybe I'll just step back here, right? So the treaty really seems to imagine individual country discretion in designing and issuing special permits under Article 8. The schedule and then resolutions that have been adopted by a simple majority elaborate on that and add these layers of review and process for the issuance of special permit whaling. What we then start to see happening as Japan I think by their standards comply with the requirements, by many others' standards maybe technically or marginally comply, but functionally don't comply with the criteria. At least that's just procedurally, and then obviously substantively, countries and advocacy organizations very much disagree that Japan's program is scientific. So you have all of these resolutions adopted by simple majorities and sometimes slimmer simple majorities than others, arguing or stating rather that Japan's program, the scientific whaling program, isn't meeting all of these criteria established in the schedule and in resolution. So, for example, in 2007, IWC members passed a resolution that calls on the government of Japan to address over 30 outstanding recommendations from the scientific committee, and specifically then calls on Japan to suspend indefinitely lethal research whaling. So significantly, the resolution also recalls that the IWC has repeatedly requested that Japan desist from issuing research permits for taking whales that are protected by commercial whaling. So things are getting fraught, right? And there's a lot of tension playing out diplomatically. We don't this is just an example of some of the tension playing out at the IWC. There are also multiple background things occurring. If you've watched our video on the Pele petition, you know that there are Pele petitions being filed and active against Japan. There are also behind the scenes diplomatic efforts to address this issue. So there's a lot going on, and really, Japan is starting to feel pinned in a corner, and the efforts of the anti-whaling countries and advocacy organizations are ramping up. So you can see here from the slide that through 2013, from the beginning of their scientific whaling program, Japan has taken over 15,000 whales. So it is a significant number of whales. And importantly, it's marketing and using the products from, or the byproducts, as it's called in the IWC context. That's a legal term that they use. Of the meat and other products throughout Japan, right? So they're not hiding by any means the fact that there are massive marketing efforts and to build and enhance the commercial markets for whaling meat and other edible products by the companies and organizations that are involved in Japanese whaling. So all of these ongoing issues and tensions and Japan's failure to respond to multilateral concerns led Australia, with New Zealand intervening, to file a case with the International Court of Justice alleging that Japan's Antarctic scientific research whaling program, so it has a whaling program in the North Pacific and it has a whaling program, in Antarctica, where it's taking whales in the designated Southern Ocean Sanctuary, so a sanctuary established through the schedule, and highly controversial for many countries. So Australia and New Zealand filed this case alleging that Japanese whaling violates Article 8 because it's actually a commercial whaling operation, and the nature and scale of the program could not be justified by the research questions Japan was allegedly trying to answer. So there's a lot of detail, and there are actually a lot of interesting facets to this case, but we're going to sort of cut to the chase a little bit. The opinion in this case looks critically at the minutiae of Japan's whaling program in Antarctica, but it does so in order to ask a relatively simple question: whether the design and implementation of the program is reasonable in light of the stated objectives, right? So this is a more neutral way and objective way of asking the question: is Japan's whaling program really scientific or is it commercial? Ultimately, the court found that no, the Antarctic research whaling program did not seem designed to answer the research questions posed. In other words, the types and numbers of whales that Japan proposed to take lethally would not yield the research results that Japan argued it sought. So in this vein, the court ordered Japan to revoke permits for the whaling program and refrain from granting further permits under Article 8 in furtherance of that program. So the last few words are critical here. The ICJ judges did not conclude that Japan could not conduct whaling under Article 8. They ruled that the specific program that they reviewed in detail didn't meet the standards for a scientific research whaling program. And any lawyer worth their salt knows what's coming next. Japan kept whaling. Right? So it scrapped the program that was found to not be in compliance with Article 8 of the ICRW, and it redesigned and renamed its whaling program. The redesign was relatively marginal, particularly in light of the holdings and the findings in the ICJ case, but arguably and technically Japan had complied with the ICJ case, although, of course, many more would argue that Japan really is defying the spirit and intent of the ruling. But there aren't any enforcement mechanisms, and really the ICJ case had only the very theoretical effect of confirming that Japan was not engaging in legally justifiable scientific whaling under the ICRW. So you can see here on the slide that this ICJ case, which took place in 2014, or the decision was issued in 2014. So between 2014 and 2019, Japan killed an additional 2,500 whales for scientific purposes. So then we enter this next era, and this is sort of the CITES era of Japanese whaling. We have CITES, if you'll recall, is the Convention on International Trade in Endangered Species. It regulates what it says. It regulates international trade, so import and export, re-export, and what we call introduction from the sea, which is when a species is taken in the marine environment and introduced beyond the jurisdiction of a state, so the high seas, and then introduced into a state. So what we have here with Japanese whaling is introduction from the sea. So we need to talk a little bit about Japan's North Pacific whaling program and its relationship to CITES, Japan's relationship to CITES, to kind of wrap our heads around what was going on under CITES. So from 2002 to 2018, Japan has hunted sei whales as part of its scientific research program in the North Pacific. So the ICJ case concerned Antarctic whaling. Now we're up in its North Pacific whaling program. So from 2002 to 2017, as you can see from this chart, Japan was taking 1,400 or had taken 1,453 sei whales from the high seas. Japan hunted these sei whales, as you can see in this little map, primarily in these IWC sub-areas 7, 8, and 9, and mostly in the area, and not mostly, in the areas that are white. And so these are the high seas. And that's important because that's specifically what makes bringing the whales that Japan is hunting into Japan introduction from the sea under CITES. So Japan was also taking other kinds of whales, but from the perspective of CITES, these sei whales are important. So Japan joined CITES in the 1990s, and at that time, Japan was engaging in scientific whaling under Article 8 of the treaty, but it wasn't taking sei whales in the North Pacific as part of its whaling program. So when it joined CITES, it took reservations. We've talked about reservations, right? Under CITES, a reservation is allowed to specific species listings in the appendices, but not to the treaty itself. So you can't take a reservation to the permit regime or to the commercial trade prohibition directly, but you can reserve when you join the treaty against the listing of certain species. And so what Japan did when it joined was look carefully at the whales it was taking currently at the time in its whaling program and took reservations to all of those whales. So at the time, it didn't include very specifically the North Pacific population of sei whale. So Japan, for sei whales, as it began to eventually hunt those North Pacific sei whales, has CITES obligations. For the other whales it brings in from its scientific whaling program in the high seas, it does not have CITES obligations because it has these legally valid reservations. And this is what ultimately, these sei whales is what ultimately led to a compliance matter being raised against Japan under CITES. And we'll look a little bit in detail at that. The important thing to know from the CITES perspective as we talk about this, just to distinguish CITES, sorry about that, just to distinguish CITES from the ICRW a little bit, CITES is concerned with trade. ICRW is concerned with the take, with the hunting, right? So it's this, it's the treaty that initially applies, and then CITES applies where a country has obligations for a specific species when it's engaging in international trade. And importantly, the sei whale is listed on Appendix 1 of CITES, which means that it's subject to a commercial trade ban. Okay, and that becomes critical as we look at this. So what the lack of reservation for North Pacific sei whales ultimately means is that when Japan is taking those sei whales in the high seas, and this is sort of a chronological graphic that goes over this, that's when the ICRW applies. When it lands them at the port in Japan, CITES applies, okay? And so recall in CITES jargon, that's when Japan has introduced from the sea sei whale specimens. At that time, Japan has to issue what we call under CITES an introduction from the sea certificate. Most importantly, for our purposes, when Japan issues that permit, it has to find that the specimens it's introducing are not to be used for primarily commercial purposes. So North Pacific sei whales are subject to a commercial trade ban. Just a quick note here for folks listening. When I use the term specimen and species throughout the CITES portion of this presentation, it's not necessarily because those are my favored words, but those are the legal terms of art under the treaty. Okay, so Japan was issuing introduction from the sea certificates and identifying the purpose of the introduction as scientific, right? So it knows that it can't introduce these sei whales for commercial purposes, but to Japan's mind, the sei whales are taken as part of its scientific research program, and so the issuance of the introduction from the sea certificate states that the reason is scientific purposes. But here, what constitutes the specimen, and again, I know that this terminology can be unpleasant for folks, but these are the terms in this particular treaty. So what turned out to be the specimen is like the key element of the application of this compliance issue for Japan. So it's this question of whether the specimen introduced from the sea was to be used for primarily commercial purposes. And we need to understand exactly what the specimen is. Okay, so just a warning here that the next slide includes more graphic pictures of Japanese whaling activities than the ones on this slide. So please be mindful of yourself. So because of the way that CITES is worded, the question of commercial use is framed as whether or not the specimen is being used for primarily commercial purposes. We need to look exactly at what Japan was landing when it arrived in port, because when issuing IFS certificates for sei whales, it has to make the finding that the specimen that is being introduced is not to be used for primarily commercial purposes. Okay, so I'm emphasizing that because here's what's interesting. Japan, when issuing these introduction from the sea certificates, had been identifying the specimen that it was introducing as the bodies of the whale. So essentially the whole whale, right? And again, from Japan's perspective, the reason it was taking and hunting the whales is because it had a scientific reason. Now, under CITES, we need to be a little bit more specific about which specimen is being introduced because there are these really important commercial trade bans that apply. So I understand that this slide has some graphic images, but it's really helpful for understanding what's going on here. So you can see it's the whale body, a whole whale that's taken from the high seas. Obviously, that's what's hunted. This is what Japan is claiming to introduce according to its introduction from the sea certificates. But as you can see from these other pictures, Japan actually processes the bodies on the vessel while at sea, and it separates the specimens it uses for its so-called scientific research from the specimens of the whale, the parts that it's using to supply a commercial marketplace. Right? So there are two types of specimens that are really being introduced when Japan lands in port. And as we were working on this issue, we were lucky to find this photograph up here that shows that the edible specimens that are being brought off the ship when Japan lands in port are packaged individually and ready for the retail market, right? So what Japan once we've gotten to actually Japan, there are two different kinds of specimens. You're not actually introducing from the sea bodies. We need to look at whether each of those types of specimens individually are being used for commercial purposes. The specimens that it was using ostensibly for scientific purpose, like the eyes and testes and stomach of the whales, like, we're not the controversial issue under CITES. It's the specimens for which there is exclusively a commercial reason for their use, right? So they're packaged directly on the ship for the retail marketplace, and it's not even a question of what does primarily mean. The only use of these specimens is a commercial use. So this slide just demonstrates where we are in the story in another way, specifically by looking at the different treaty requirements that apply along the Japanese whaling supply chain. So this is really a review of what we've just talked about. So as you can see here, takes the whales, it's the ICRW, there's the byproducts and processing provision in Article 8 of the ICRW, right, which gives Japan the right under that treaty to process the whales it's taking for scientific purposes and use the byproducts as it sees fit. But then we get to CITES. So as soon as those byproducts are landed, right, they become specimens under CITES, and introduction from the sea certificates are required, and Japan cannot legally issue introduction from the sea certificates for specimens that are going to be used for primarily commercial purposes. Okay. So ultimately, what this meant is that Japan was found to be in non-compliance with CITES. The Standing Committee, which is the body that handles CITES matters, took many years to review this issue with feedback from Japan, with review from the Secretariat, a visit from the Secretariat, a mission to Japan. But ultimately, the Standing Committee agreed that Japan was in non-compliance. And this is an interesting outcome for Japanese scientific whaling, because the sei whale from the North Pacific program, like, we know from much advocacy and work and research being done in Japan that the market for whale meat is dwindling. To the extent there is a market, sei whale is preferred. And so sei whale was providing the financial backing that was important to complement the massive government subsidies that were funding Japanese scientific whaling. And without that without the financial support that the sei whales provided, Japanese scientific whaling, particularly all the way down in Antarctica, became financially unreasonable for Japan to continue to pursue. So what happens is that Japan, it doesn't withdraw from CITES, it accepts the non-compliance and stops taking sei whales in the high seas. In fact, it stops taking whales in the high seas entirely. So it closes its Antarctic research program, it closes its North Pacific research program. But then what it does is it withdraws from the International Convention on the Regulation of Whaling. So ultimately, this means that Japan worries less about the commercial whaling moratorium, but it restricts its whaling to its own coastal and jurisdictional waters. So none of these legal interventions have had the effect of stopping Japan from whaling, but each one has shaped the course of Japanese whaling. And the consequence right now is that Japan has resumed overtly commercial whaling. Right now it talks about its whaling as a commercial whaling program, but it's doing that whaling in its EEZ, or its exclusive economic zone, its jurisdictional waters, and not in the high seas, including, as we said, no longer whaling in the Southern Ocean Sanctuary. And as you can see here, this was pretty big news in major newspapers and sources. So let's look at Japanese whaling since then, just in terms of numbers, and really ask about the effectiveness of these legal interventions. Like I said, it's true that none of these legal efforts have had the effect of putting an end to Japanese whaling, but arguably that over decades these legal efforts have destabilized and even crippled Japan's whaling efforts. The number of whales that Japan has killed since it resumed commercial whaling are half of what it had been killing under its scientific whaling programs. So whales are still losing their lives. I'm not diminishing that, but we have seen a reduction. So for some individual whales, there's a win, but there are huge questions about the future of Japanese whaling, and that's particularly true because Japan has just brought a new whaling vessel online. So those involved, according to news articles in Japanese whaling, insist that commercial whaling will not resume in the Antarctic because it's cost prohibitive. But this shiny new vessel certainly has advocates worried. Ultimately, I hope that this legal history of Japanese whaling has been interesting. I apologize, there were minor snafus with the slides, but those will also be posted separately. It's a hard story to tell because the wins haven't really been full wins. And it's hard to see the light at the end of the tunnel as a whale advocate here. So whether this is a story of tireless advocacy, achieving incremental progress that's moved slowly but surely in the right direction, or a story of the resiliency of Japanese whaling is really in the eye of the beholder, and maybe, as my grandma likes to say, 6 to 1, half dozen to the other. So thank you very much for listening, and I hope you enjoyed this history. Thank you so much.